Thanks. All right. Thanks, Anne. Appreciate the lovely introduction as always. Let me see if I'm able to share my screen and get this slideshow off and running. Okay. So,
From the beginning. There you go.
very biblical, Anne. I like that. Um, okay, here we go. Oops, let's not get ahead of ourselves. Which way do we go? All right, there we go. So this is having fun with Costa doing a presentation. So my name, for those of you who do not know me or haven't had what I will euphemistically call the pleasure, my name is Kostantine Demiris. I go by Costa for short. It's a Greek name. My parents were very proud Greek people, and so they decided to make my life as difficult as possible in the 80s with a name like Constantine. So my presentation today is in regards to elder care needs and what type of placement is appropriate. Oftentimes in this practice area, this is the part that is not given the attention that many people feel it deserves. So I think this will be a helpful presentation for most of us who deal with these types of matters. So number one, what type of level of care is appropriate, and the notion of people staying in their home and home being where the heart is. The level of care, levels of care range from primary to secondary and tertiary, and all additional levels. But what often is required in the analysis is where is the person placed, and where is the person residing at. So it can depend on their residence or location. Elders who are in a situation such as a conservatorship are generally provided preference in regards to their placement being at their current residence or their home. People who are not in a conservatorship naturally have freedoms to pick and choose where they would want to be, unless they are incapable or have been deemed to be unable to make their own decisions by whether that is a power of attorney or a court order of some sort. So in this situation for today, what we're going to be dealing with is in a conservatorship scenario, or in a scenario where a person is in need of a level of care beyond just what all of us, I think, experience, how they would go about that and how that would be analyzed. Generally speaking, for conservatees, you have the General Counsel Form GC 335 that is entitled Determination of Conservatee's Appropriate Level of Care. And that has criterion in regards to what should be looked at for determining where the conservatee is living and where the conservatee may be living in the future and the level of care that person needs. It is important to note that the term that we use quite often of home and residence for purposes of the law are not necessarily the same thing. So we will dive into this. I won't spend a lot of time on this, but I think it is instructive because a lot of times people say, you can't do this, you're taking the person out of their home, or the person wanted to be at their home, but the legal term is going to be residence. So a person in a situation like this, which we're talking about, could own a very nice home, have lived there for 30 years, but if they are currently residing elsewhere, then the residence could be where they are currently residing at, and the law makes it such. There are forms for conservatorships that deal with pre-move change of residence. That has to be done when you're in a conservatorship at least 15 days before the quote move or change of residence. Again, this can be a bit amorphous because you can have a situation where a person is in theory living somewhere other than where they've been most of their life, and that is the place they consider their residence. And so we will dive into that going through the CRC, which is the place that has all of that outlined. So under California Rules of Court 7.1063, yes, there are that many rules of court. The conservatee's personal residence is a situation where under that section, it is the place that the conservatee understands or believes or reasonably appears to understand or believe to be his or her permanent residence on the date the first petition for appointment of conservator was filed, and that is whether or not the conservatee is living in that residence on that date. So just like what we were talking about, you can have a scenario where a person has been living in their home for 30 years, but the person now is living with the son or daughter or at a facility somewhere, and or not, but wants to live there and believes that to be their residence. That would be enough to be considered that person's residence under this rule of court. And I've highlighted that a residential care facility, including a board and care, intermediate care, skilled nursing, or secured perimeter facility, may be the conservatee's personal residence under this rule. And we will go through each of those types of levels of care and placement so that everyone is aware of what those entail. And again, this means that you can actually have a residence somewhere other than where you are even currently living at. So it's an interesting situation in that regard for purposes of the law. Now, I posit a question at the bottom, which is what happens if the conservatee cannot formulate a belief? So, that is the cliffhanger for the next slide, and that is taking us to the next part of that rule of court. If the conservatee cannot form or communicate an understanding or belief concerning his or her permanent residence on the date the first petition for appointment of conservator was filed, his or her personal residence under the rule is the residence that he or she last previously understood or believed or appeared to understand or believe to be his or her permanent residence. So again, we go from amorphous to even more of a murky situation. What are we going to do based on the date of the first petition if a person does not appear to understand or have the capacity to state where they're residing at or where they believe to be, or if they give two different answers? So we can have a lot of weird combinations, but this is a situation where I ask, what if there were changes done quickly in time? And you can have a situation where a person is living in a home, has a healthcare issue arise, is moved to a hospital, then moved to a residential facility, or is moved to a skilled nursing facility or an immediate care facility, and then moved to another place. So depending on the moves, depending on the timing, depending on what the person remembers or believes, you see a lot of things that can change what is legally considered to be that person's personal residence under the law. So some tools that I think would be helpful in delineating what that person's true residence is to eliminate confusion in situations where there may be a capacity issue or pure confusion is to get a capacity declaration. That way you can find out whether this person who is being asked to make a decision or state what they believe to be their level of care or placement is able or unable to do so. Otherwise, petition the court for an order to clarify, and that can often lead to an evidentiary hearing if there is a dispute or contest involving other people. What is or is not a change of personal residence? This is one of those questions that is codified in the rule of court, and a move from a person's who is a conservatee personal residence to a residential care facility or another residence is considered a change of the conservatee's personal residence. A move from a residential care facility or other residence to another residence that is not the conservatee's personal residence is a change as well. And then a move from a residential care facility or other residence to the conservatee's personal residence under this rule is not a change. So if that hasn't confused you, you'll probably need to read it a few more times. But in essence, what it is saying is that if you move a conservatee to a higher level of care, if you take them from their personal residence and you move them to a residential care facility or another residence, then that's a change. If you have a situation at the bottom, item C, where they're already at this higher level of care, a residential care facility, or they're at another residence that's not where they started at, not the place that they were living at, and then you move them back, that would not be considered a change of the conservatee's personal residence. So now we're diving into levels of care, and that's important because once we realize where the person is living, especially in a conservatorship, that is instructive as to what type of care they can obtain. The primary and preferred option oftentimes is the home and or a residential location. And that is a tradition, custom, social norm. It doesn't necessarily fit all circumstances. But if a person is at home and cannot care for themselves, then they would need what is known as a caregiver or an in-home caregiver. And that definition can be quite amorphous. The person can be a relative, a family friend, or even a professional caregiver. A lot of times people who have other people take care of them or do little things like cook a meal or bring in the mail or feed the cat, don't consider themselves to be a caregiver. They just say, hey, I'm helping out my neighbor. My neighbor is older or my neighbor needs some help, whatever. So this can also get a bit amorphous at times. One thing to keep in mind that is very important when advising clients or even looking into situations involving caregivers for people who live in their home is that a caregiver does not have to be licensed in California. So this is good and bad. It has situations that allow for many people to have care where they may not otherwise have care. But at the same time, it allows certain types of individuals to be caregivers that perhaps we would not want to be caregivers. That being said, there are licensed caregivers in California, and they have a licensing requirement. One thing to keep in mind in regards to any caregivers that are hired is that they are paid and that complies with California legal requirements. Oftentimes people are surprised that when someone does something for them in a caregiver fashion, that person may later have a claim. That can happen when someone's providing 24/7 care or providing what I was just talking about, other forms of care. And these claims can be made during the person's life or post-death. So that can be a shock to a lot of people who think, hey, you know what, I just have a good friend. They're just providing this gift or what have you to me or to my mom or dad or whoever. And then you find out down the road, well, that comes with a bill attached. So it's always, in my opinion, a good idea to have a licensed caregiver if that's what is actually needed for a person in a situation where things aren't otherwise clear in regards to whether there's going to be pay or not, for obvious reasons, such as having a basic understanding of what needs to be done, having a clean record or a clear record of what the idea is of what the care that is being provided will be for and any compensation, and to also have a background check. Sometimes we have people who say, this person knocked on my door and said that they were willing to help out. And that person may actually have good intentions, that person may actually be a good person, but the reality is that that can be also quite a red flag, especially when that person does not do it for pay initially, and then years go by and there can be family disputes or dramas in regards to what that person's role is. Um, Caregiver certification uh, involves a professional organization known as the PAC, Professional Association of Caregivers. I provided the link as well. It provides for coursework and testing. Surprisingly or not surprisingly, the test that is provided only requires a 75% correct rate in order to pass the test. And so you're looking at essentially what high school kids are calling a C result to pass the test, and the exam can be retaken. So if a person approaches someone or is claiming to be a licensed or certified caregiver, oftentimes, people don't say, well, when did you take the test? How often have you taken the test? Did you fail the test? What were your scores on the test? But those may be important questions to ask depending on the circumstances, and as well as in a litigation scenario, because if a person is claiming to be certified or licensed and they've failed the test multiple times, it would be good to know the reason why and to potentially get those test scores. Now, getting into the levels of care and the types of facilities, you have what are known as assisted residential facilities or residential care facilities, depending on how you want to use the nomenclature. They're often referred to as ARFs. Those tend to be off-site locations. They're non-medical facilities. They provide room and board for the most part, so meals, also housekeeping, supervision, storage, distribution of medications, personal care assistance, and other services as well. I like to call it, essentially an apartment / dorm style living situation, or like a college environment for the elderly. So you can have one person in their own apartment, and they can have like a little kitchenette or a dining area, their own bedroom, a living room. So it's actually kind of a cute little way to live. And then you can walk out of your apartment down the hall, and there's usually a community center or an area where you can meet with other people, engage in activities. Many of these places have community-based living arrangements where other people who say have a car can take people to the store or go shopping. And there are a lot of social activities, programs, travel opportunities, and things that can be done. Oftentimes, as people age, they have less socialization than when they're younger because of just natural circumstances. Kids grow up, move out of the house, have their busy lives, people die off, and then other people who survive are left to be in a more lonely situation. So, a person living at a facility, such as a residential care facility, can sometimes be in a better position than living at home when it comes to socialization, especially if that person is not a social person or needs socialization, has otherwise hermit-like stay-at-home tendencies that may actually cause them psychiatric or other forms of harm. So that's something just to keep in mind. Another important function in regards to residential care facilities is that they require compliance with state laws, rules, and regulations. Now, what is often looked as at a level that is higher than a residential care facility is a board and care, but for purposes of the law, they're not necessarily looked at as a higher level of care, but they often are and can be. A board and care facility is typically an actual home that's converted for care. You may not even recognize board and care just driving around a neighborhood. Whereas an assisted, a residential care facility, I should say, is a place where you would see a sign that would likely have a parking lot. You would know that this is something that houses many people. And board and cares are usually smaller than an assisted residential facility. It's usually, like I said, just a house that you may see in your neighborhood, but it has converted rooms for providing care for elderly individuals and or people with need. And it is also state licensed. It's a non-nursing situation, and it does allow, for people to have a more affordable care option than an assisted residential facility. You usually would have up to 2 people in a bedroom. You can have a person who has their own room as well. But oftentimes, if you're looking at in the neighborhood of $10,000 a month for a room, having the ability to cut that in half by sharing a room with someone can be very appealing to people. It also allows for increased socialization. While privacy can be a positive, it can also be a negative. So if a person likes to talk or is someone who really would benefit from having a companionship or simply the presence of another person near them, that would be something that could be looked into. With that comes less privacy, as we were discussing, and you usually are sharing things. So you're going to be in a situation where the individual could be sharing a bathroom and or sharing a TV, maybe sharing a closet area. So it is more of a situation where sharing and being more open with the person that the elder is living with would have to be acceptable to them, and some people are just not acceptable to that. And as I stated earlier, you may not even know that you have one in your neighborhood. Now, getting into nursing homes and skilled nursing facilities. When I grew up, my mom worked at the VA hospital, and there was a nursing home, and they had various patients there, and I would go and visit the patients and or wheel them to occupational therapy or physical therapy, and they had Alzheimer units and different units. So a nursing home is not necessarily a skilled nursing facility, but it can be. It is out of a person's home. It can be attached to a hospital. It can be near a hospital. It can be its own standalone facility. It can also be part of a facility that is an assisted residential facility and have a dynamic where it allows for transitioning to a skilled nursing facility that's on site. So most nursing homes in California are licensed. A skilled nursing facility is an inpatient rehab and medical treatment center that is staffed with trained medical professionals who provide necessary services with licensed nurses. And as I was talking about, physical and occupational therapists, PT, OT, and speech pathologists and audiologists. So, this is usually for a person who is in acute care, are bedridden, can be severely disabled, wheelchair bound, or have advanced Alzheimer's or severe neurocognitive disorder. Most California nursing homes are certified to participate in both Medicare, which is a federal funding source, and Medi-Cal, which is state level for California. Just remember that federal certified facilities have to meet federal standards as well as California standards. So when looking into skilled nursing facilities and nursing homes, not all of them have the same baseline requirements. So not all of them are created, nor do they operate equally. These are things to look into. And as I was stating earlier, Some locations actually have multi-dimensional care options to allow for the transitioning of residents. So if you have a situation where an elder or an individual who is in need of future care doesn't like to move a lot, or with being in the Bay Area, the alarming rate of having difficulty in finding housing, and the need to have housing available, having a person in a place where these things are all lined up can be beneficial. And now there are places that have, like I said, a residential side or floor or place, and then a skilled nursing option as well. And then that way it avoids having to move the person multiple times, and they can be in a place where they want to be at. One other level of care that's lower than a nursing home is an immediate care facility. Back when I was going through the definitions of the types of levels of care for a person, this one was listed. It still requires licensing, and that's done by the California Department of Public Health. It's a situation where it allows for inpatient care to people who do not require continuous nursing care. And it also does provide for a little more freedom, as the people would not need constant nursing supervision. So that's the difference. When you have a skilled nursing facility, remember the word nursing, versus immediate care facility, which does not have that word in there. And also remember that these ICFs can be, and often are, going to be at a lower rate in regards to payments on the government side. So for Medi-Cal, you're going to be looking at usually a situation where you're not going to be getting as much for what you are looking for. And it does state that Medicare does not certify or pay ICFs. So if you're looking for federal funding, you won't get it for an ICF. State funding you can, but it depends on the facility, and it'll likely be less than at a skilled nursing facility. This leads us to the level of care that a person may have in placement issues. So, oftentimes people are left with decisions. They're, dealing with a loved one who's elderly, or even when they are transitioning in their later years, where do I want to be? How do I want to live the rest of my life? California does offer options such as Medi-Cal planning. That's not something I'm going to deep dive today, but there are things that can happen where people spend down their money in a certain manner that's required by law to qualify for Medi-Cal, and to allow the elder to obtain Medi-Cal benefits. That can also get murky and be quite dangerous, because sometimes relatives or loved ones look and say, hey, why is dad giving all of his money to my brother and has nothing left over? And why is he getting put into a home? Or why is he getting put into a facility? Or why is he no longer able to live the life that he used to live? So depending on how things are done, people can look at these certain acts that can otherwise be possibly benign and be confused and or have appearances of elder abuse. And oftentimes, you can have a situation where there is this type of confusion, and it can lead to litigation. It's not always the case, but it can. The other thing with levels of care and placement issues is, what is fair pay? As what we were talking about earlier and discussing, if you get into a situation where a person is providing care, but it's not defined, if a person is doing certain work, if a person is a relative, or a person is defined in the estate plan, if they're already providing gifts, how does that all factor in? So, those are things that can get murky. Think about a situation where a person says, I want to give money to this person who is helping me to show them my appreciation, and I'm going to do it in my estate plan. For those of us involved in this field, we know that there are certain prohibited transferees, and caregivers are one of them. So it is better and more optimal to simply have a written contract and pay that person as they provide the service, rather than put them in an estate plan unless it's done properly with a certificate of independent review. So those are things that, as I state, can get murky if not done right. A lot of times people just say, hey, I trust you, there's nothing to worry about. And, that can work a lot of the time, but the times that it doesn't work, it can be really bad. Other things to think about are when an elder or a person who is in the need of care is at a location, but they don't necessarily like the location, or they want improvements, or they don't like the type of care that's provided, or there are other people present who they are not fond of or don't want to deal with. These are all things that can get murky. For example, people who are frugal their whole life and yet towards the end of their days need increased levels of care may have a child or someone involved in helping them out who is doing their best to keep them in their home. And that could mean remodeling the home, spending in the Bay Area several hundreds of thousands of dollars to remodel the home. And that can irk other children or other beneficiaries post-death who are saying, hey, wait a minute, you spent a lot of money. Why did you do that? And those people were not there to deal with the situation involving the elder, but those are also things to be aware of. And like I said, the type of care and other people, the elder's wishes should always be highly respected and honored as possible, especially in a situation where they have the ability to make independent judgment. So the best solution that I see, and from my experience, is to have as open a communication avenue as possible, especially with family members. It's a difficult situation when people are surprised. It usually creates an emotional reaction. It's very difficult sometimes for people to deal with their feelings when they're told something that they've never expected to hear for the first time. So, that's just something to be aware of. But, open communication and probably doing it in the right manner should also be included. Finally, when dealing with people who can be troublesome or difficult in regards to sharing information or providing information, sometimes court involvement is necessary to make things as clear as possible for everyone. You can have a situation where an elder feels very strongly and has made a decision, and others disagree with that decision or feel that the elder is being manipulated. You can have a situation where the elder is not able to understand certain types of consequences of their actions and are causing great worry and distress to those around them. So in situations where communication fails and other attempts fail, sometimes court involvement as a last resort is necessary. And as I was talking about, some examples are people change their minds, their feelings, and they are emotional creatures. I can't tell you how many times I have people tell me the word never. I would never do that. I will never do that. When I was a kid, I said I would never like broccoli. I said I would never do a lot of things. And, now I really like broccoli, and I've done things that, looking back on when I was a kid, I couldn't believe that, I felt that way or that I feel the way I do now. So people do change, people do develop, and people do have feelings and emotions. So losing a loved one can be a very traumatic experience where a person can sit back in their chair and say, well, when my spouse is gone, I'll be happy to do this. And then they lose their spouse and they have a totally different perspective. So I think having a little bit of flexibility as well in regards to what people may have written down in their wishes, where they're at, and where they want to go is important as well. So that's it. That's the presentation. I'm happy to answer any questions or open the floor for any discussion.
Really well done. Very good.
Thanks, Julie. Appreciate it.
I'm impressed by the knowledge of your, the depth of your knowledge on this subject. I really don't have any questions. I think you covered everything really well.
Thank you for the compliment. Appreciate that.
Do you like broccoli now?
I do. I would show you some broccoli, but I don't want to go too over the top.
Okay. Does anybody have any questions? Joel?
Yes. My question deals with the senior who owns their own home, wants to preserve it until they die so that their heirs can get the benefit of inheriting it and getting their stepped up basis on the one hand and keeping their low Prop 13 value on the other. But they come to a point where they may need to leave their home in order to go into a facility. And the question, I guess, deals with whether they can retain their residence in their home that they want to preserve with the intent of returning to it if their situation changes, but needing help that they can't get in their home alone. And the question is how one deals with that so they could preserve those intentions to preserve their value. And also, if they keep their home, of course, they're not required to spend down the home itself as an exempt asset. So that gives them a unique opportunity not to have to spend down their entire estate that they wish to leave to their descendants.
Yeah, no, that's a very good point. And I mean, reverse mortgages and other financial tools or options to allow people to stay at their home. The pluses to that are, like you stated, that the home can be passed on post death, and there can be tax advantages to that. The negative is that that is only at the present time. I mean, California is an evolving creature, as we know, and the taxation power of the state has changed dramatically in the past year, especially in regards to real estate transfers. So I don't know if that's going to stop. I don't know if that's going to change, if that's going to be static. So that's something also to keep in mind. I think one of the interesting things is, as planners go and as elder law attorneys go, we are advising people in regards to a moving target that is partially hidden from us. So, I mean, we don't know where that exactly is going to land. And so we can throw a dart and hope that it hits the bullseye. And by the time it gets to that area, the mark has already changed. So, I mean, I think that's also important in the federal government. I mean, there are a lot of moving parts, but I do agree with your premise, in regards to finding ways to keep people in their home. Those are all great options right now.
By the way, you mentioned reverse mortgages. The problem is that they put a limit on a 1 year on staying in your home if you should leave. And I'm wondering if there's a solution for that problem.
So that is fascinating. I mean, I think those of us who have dealt with reverse mortgages and what I was talking about in regards to placement and change of residence, can dive into that deeper. But that's one of those amorphous situations where you can perhaps have a person who's not actually in their house, but their home is still their residence, and they may be at a facility for a period of time and not lose certain rights. Now, it depends on the contract, it depends on what the terms of the contract are. Some contracts are much more specific than what I'm talking about. They may actually require physical occupation of the real property for a certain amount of time. So all of those things would need to be looked into. Ann, do you have any questions?
I do not. I just went through all this, so we made all those decisions pretty well on the way down, so we got them all taken care of. So I'm glad we, personally, took care of things appropriately, according to you. The next question I have: does anybody have any other questions? Just general family law, or sorry, elder law questions. This is meant to be a little bit of a discussion forum too. If anybody has anything they want to throw at Costa. Okay.